Good morning. Good morning, everyone. I hope you all are doing great today. It's Friday and I'm looking forward to the weekend. So, there has been a couple of breaking news, and I thought it was a good time to go into it with you guys so that I can dissect it for you. And yeah, so for those who are joining me for the first time, my name is Ifama Odunlami. I'm an immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. We're a national law firm, which means that we service clients all over the 50 states of the United States. And today, for the first time, I'm live on TikTok. So I want to say hi to TikTok followers. I'm sorry I've neglected you guys for so long, but I was trying to figure out how to get on TikTok. I figured it out now. So, guys, there's a lot of good information going out, and I want to go over it with you. And I'll take a couple of questions before I get off. So, like I said, for those who do not know me, my name is Ifama Odunlami from the Odunlami Law Firm. We're here for immigration attorneys, immigration clients. I'm an immigration attorney. I'm also an immigrant. So is my staff, and we've been through a lot of this process. And our passion and our mission is to assist other immigrants who are looking to get legal status. I do these lives typically once a week because it's important to give you guys information. Intending immigrants are typically victims of scams. There's actually a website to report scams. If you go to the USCIS website, I think there's a place where they tell you that you can click on it to report immigration scams. So just be careful about the information that you're receiving from people reaching out to you. I actually even have people trying to uh, pretend to be me and reaching out to clients. So just be careful. Make sure that the only social media platform that you're following are the ones that you are on now, the ones that have significant followings. So typically, the the scammers they have zero followers, zero following. Just be careful. And also, the USCIS website also urges you guys to be careful, and I will go into some of the things they talk about, the ways to figure out maybe people who are trying to scam you. But for right now, I want to get into the topic that I want to discuss. And thank you guys for joining me. Hello, everybody, and thank you, thank you, thank you. So we're going to talk about Biden's parole in place. So finally, we've been waiting for this news forever. They gave us a date when it's going to get started. The parole in place, let me define this, what this is. The parole in place is the new program that the Biden administration implemented, which is supposed to help undocumented spouses of U.S. citizens and undocumented children of children, stepchildren of U.S. citizens who qualify. So the rules are really strict, guys. You're not going to get in through any other way if it's for this. So I just want to be sure that you understand who qualifies. So basically, the idea behind the Biden's parole in place basically is this. If you came in through the border without admission, without parole, if you were to get married to a US citizen in the United States, you're not going to be able to adjust your status to get your green card. You would have to file a waiver to forgive your manner of entry. And that waiver, if approved, asks that you go back to your country, go to the American embassy, go for an interview, and then you're allowed to come back in and get your green card. So the Biden's parole in place basically takes away that requirement that you go back to your country. So what it's doing is you don't need a waiver anymore. You can stay here if you qualify for the parole in place. If you qualify, you can stay within the United States, adjust your status, get your green card, and all that. So I want to be very clear because I've gotten a lot of calls about people who think they may qualify. If you came with a visa, even if your visa has expired, you do not qualify. And don't let anybody tell you that you qualify. You do not. So I'm going to read out the four criteria which required for you to decide that this is something you should do and put in your application. Now, parole in place is not automatic. It's discretionary, so you have to show that you merit a favorable exercise of discretion. So the first thing is you have to show that you have to be first of all show that you came in without inspection, without parole, and typically that could mean you came in through the border, right? So that's number one. Number two, you have to show that you've been continuously present in the United States for at least 10 years as of June 17th, 1994. June 17th, 2024. Mark that date. You have to have been continuously present for 10 years as of June 17th, 2024. And the third thing is you have to show that you're legally married to a U.S. citizen as of June 17th, 2024, right? And the fourth thing is you have to show you do not have any disqualifying criminal history or otherwise constitute a threat to national security or public safety. So we don't know a lot of it. We don't have any information right now about how this parole in place is going to be implemented. So USCIS has not provided any information, no forms, nothing. And so what they're saying is they will provide this information in the Federal Register probably in a couple of weeks. You cannot submit any application prior to August 19, 2024. It will be rejected. And so if there's somebody out there now who's asking you to retain them for that, you want to be careful about that because we don't even know what the requirements are going to be. So the thing to do right now, actually, USCIS on their website is telling you this is what you need to be doing while you wait. And I'm going to go over it with you. So the USCIS website says that you should begin at this time to begin to put in basically to get your paperwork together, right? They're not accepting applications, but you can begin to prepare to file a parole application by gathering evidence of your eligibility, such as, now, one thing is if you're married to a U.S. citizen, you want to show that that person is a U.S. citizen. So you want to have proof that your spouse is a U.S. citizen, proof of, would be proof such as their birth certificate, their naturalization certificate, their birth certificate, if I said that before, passport, American passport. You have to have proof of that. You have to have your own identification documents, your passport, your birth certificate, your driver's license, whatever it is, right? And USCIS says it could include expired documents. So if your document is expired, nothing to go crazy about. Now, you also have to show that you came in without a visa. So if you have a visa, they're going to know because it's in the system. You have to be able to, show that, well, you may not be able to show that you came in through the border, but you want to show that you don't have a passport. You didn't get a visa. You didn't come here with a visa. So some people are caught at the border when they're trying to come in. So they have proof that they came in. But you want to make sure that if you were allowed to come in, you were not paroled in, right? You want to make sure of that. So now documents, you have to establish documents to show that you've been in this country for 10 years. And that's proof of your presence. To get this, what you're looking for is receipts, rent receipts, utility bills, and typically you want to show that for, if you can get one for every month, that you've been here, that's helpful. Or if you can't, just do the best you can. You want to get rent receipt, utility bills, school records, report cards, hospital or medical records, attestations to your residence by religious entities, unions, organizations identifying you by name. All of this information is in the USCIS website. So, just go take a look at it. If you have official records from a religious entity confirming your participation in a religious ceremony, which shows that you were here, that would help. If you have money order receipts, that you sent in or outside the United States, you have children that were born here, you have their birth certificates, that would be helpful. you have dated bank transactions, that would be super helpful. You have automobile license receipts, title or registration, deeds, mortgages or rental agreement contracts, insurance policies, tax receipts, tax returns, and all of that stuff. I mean, this is not an exhaustive list by any stretch of the imagination. Now, if you have a child who is also undocumented, who also came through without admission or inspection, and that child could be a stepchild to your U.S. citizen spouse, which means that your marriage took place before the child turned 18. You will be your U.S. citizen spouse will be in a position to be a relative that can file for them, and so your child can also apply for PIP. So for that, you want to show the child's birth certificate, which is an identifying document. You want to show the child's presence in the United States as well for 10 years, as long as depending on their age, as of June 17, 2024. You want to show the qualifying relationship, which is your marriage license that shows that that child was under the age of 18 as of June, as of the time you got married to your spouse. So these are important things that you should know. And then USCIS goes forward to tell you to beware of scams. And they tell you that one of the things you should look out for is people who are the notarios. Notarios are not authorized to provide you with legal services. Only an attorney or accredited representative can provide you with legal services. And they tell you that the signs of an unethical practitioner may include people promising you guaranteed outcomes or money-back guarantees, using predatory or threatening pricing structures, asking you to sign a blank paper or not allowing you to review a paper you have signed, and asking to keep your signature on file. So to protect yourself from potential scams, do not pay for government application forms, unless it's attached to the form that you're submitting. Ask for a written agreement that describes the services that the person is providing for you. Get copies of documents prepared for you, and ask for a written receipt that includes the name and address of the provider. So those are things that you need to know. And then I'm going to talk about, I know some people have asked me if they have, multiple entries, whether they would qualify for Biden's parole in place. It doesn't appear that they would, because multiple entries is a permanent ban. And from what I have gathered so far, the Biden's parole in place is applicable to people who would otherwise be able to adjust their status, but for their manner of entry. All right. So we're going to know more information as, when the Biden administration releases it. So for now, just go ahead and get all these documents together and wait to hear more information. Now, I want to talk about the Haitian TPS. That's the next thing in the news, and then I'll answer some questions, and then we can go from there. The TPS for Haitian, our Haitian family has been redesignated. Right, this was done I think a week ago, and so I want to remind you guys of what you need to do. It's designated through February 3rd, 2026. For those who already have TPS, you can re-register, but you only have 60 days to re-register, which is July 1, 2024 through August 30th, 2024. And I urge you to do this as soon as possible, because sometimes when you make a mistake, USCIS will return all your documents, and a lot of times they'll return it after the date that you're supposed to put in the submission, and that would put you in a position where you cannot re-register for TPS. So the best thing to do is to put in the application right now, and if there's any issues, hopefully you'll get it returned to you in time enough for you to correct the error and send it out again. Now, for those who are registering for the first time, you can register from July 1, 2024 through February 3rd, 2026. I urge you to do this because TPS really helps you. It helps you get a work permit. It's, you're allowed to stay here. You don't have fear of deportation for as long as the TPS is designated for your country. Now, what are the requirements? You have to show that you have had continuous residence in the United States as of June 3rd, 2024, and continuous physical presence as of August 4, 2024. And so that's what you need to know for now. So my Haitian family, get to it, okay? So I'm going to take a couple questions and then we can go from there. Hello, Bukola. Thank you. Thank you. You're welcome. Squash 6 says, how long does it take for a parent with a green card to file for a child under 21? So Squash, that's a really great question. And it really depends. First of all, it depends on where you are, because if you are here in the United States, what you need to know is that that child has to be in legal status. And because there is a priority date, you are going to have to make sure that when you file for the child, you have to wait for that child's priority date to be reached before you can take the next step. And if you're in the United States, that child has to be in legal status. Now, for those, and that could take a couple of years, really, because you have to look at the visa bulletin to see what cases they're working on under F2A, which would be a parent filing for a child under the age of 21, a green card parent filing for a child under the age of 21. Now, for a green card holder parent who has a child outside the United States, you also have to wait until the priority date is reached. There's no requirement for your child to be legal because you're abroad, so that's fine. However, the consular process itself takes a longer time. So you're going to have to add that. So it's going to take much longer for somebody who's filing for a child abroad than that who's filing for a child in the United States. And honestly, I don't think it's going to take anything less than 3 years. But I really can't tell you because the visa bulletin changes every month. Sometimes they move forward, sometimes they don't. So I'm going to encourage you to look at the visa bulletin and just kind of keep an eye on it, okay? So the next question is, Marvin says, the thing is, it's going to be really hard to qualify for this parole, even if you have all the qualifying things. But we do know this category has bars, so we are screwed up. Marvin, I don't really think, no, I don't agree with you. There are many people who have had to file a 601A, and lots, according to the statistics, over 500,000 people will actually benefit from this parole in place. So don't assume that you're screwed. If the only reason you couldn't adjust your status in the United States was because of the manner of your entry and you would have to file a 601A to go outside, then this would work for that person as long as the person doesn't, have any other inadmissibilities. So I think you should not think of it in terms of being screwed, because a lot of people are not screwed. Are there people who may not qualify? Yeah, certainly. But hi, Christine Wisdom. Hi, thank you so much. So our world says, good morning. How long will it take for a change of status to F1 to be approved? It depends. I really don't know. I-539's change of status, or it isn't taking, I would say, a couple of months, but I really don't know off the top of my head, because that's not I think we've done a couple, but that's not an area we typically keep records of. Okay, so let me go to Instagram, see if I can grab some questions from there. And hey, TikTok, this is my first time coming on TikTok and I'm so excited. How are you guys doing? Good morning. Let me grab some questions from Instagram, and then I'll see if you have questions on TikTok as well. I'm looking forward to getting to know the TikTok community, because I have quite a bit of followers there. So let's see if I can get a couple of questions from here. I have, okay. So I have Real Midday. Josh says, my question is, can you travel to Nigeria with a pending I-751 expired green card, and a notice of receipt. Thank you. Yes, real midday, Josh. So when you have a pending I-751, they typically give you an extension letter, right? So if you're going to travel outside the United States, you want to take the expired green card, the extension letter, and you should be fine. So that's what the extension letter is supposed to be for. It extends your stay. Now, if you're someone who's a little anxious and you want to make sure that, you can go and get an I-551 stamp, but really the I-751 extension letter and your expired green card represents an active green card, All right. Have fun in Nigeria. So let's look for more questions. All right. I'm married to a U.S. citizen, and my kids and I have been granted a 10-year green card last year. My husband is threatening a divorce because he says he's not happy. This is a question from At Home with Bertha. Will a divorce affect our citizenship? So at Home with Bertha, you have a 10-year green card, which is great. It's a permanent green card. So if your husband decides to file a divorce, all that means is that you're going to have to wait for 5 years from when you got your green card to apply for naturalization, right? And after 5 years, you can apply for naturalization. Sometimes USCIS wants to go back and, snoop around to make sure that relationship was legitimate and all that. But typically, him filing a divorce, the only way it really affects you is that you have to wait for 5 years before you can apply for naturalization. All right. I hope that answers your question. So let's go. All right, let's see. I'm not seeing any more questions on Insta. So, okay, I have a question right here. So, as say Ibrahim says, if USCIS approves your travel document, did they approve your green card too? No. As say, your travel document, which is advanced parole, only allows you to travel outside the United States while your case is pending. It's not a green card approval by any stretch of the imagination. So you want to be really careful about that. And does an approval of your advanced parole travel document mean that your green card is going to be approved? No. So if you want to travel with advanced parole, just know that it's not a guaranteed automatic entry. It allows you to go outside and come back. But if you have any inadmissibilities, you might want, like you've been arrested, I would not advise that you travel. And, so just be advised. So Franek Talk says, if you filed for waiver 601 overstay, what can you do? And I-130 has been approved for over 10 years plus. Well, Franet Talk, if you file for the 601A, and I'm suspecting that's still pending, this parole in place may be helpful for you because you already have an approved I-130. So if the parole in place is able to allow, is approved, then you don't need to travel. And that's what the 601A would have done. It would have allowed you to travel outside the country. Now, if you're approved for the parole in place, you would not need to travel. So that's really great news. A lot of people do not want to leave the United States until they get their green card. So Alebe says, my wife is an active military personnel and she filed my I-130 application and it's taking so much time than expected. Any idea on how to expedite this process? Unfortunately, sometimes it takes time, and the only way to expedite this process is really if there's humanitarian concerns, life or death matters, all right? And there's no guarantee that it's going to be approved because they're typically really, really hard to approve. So Seymour says, I was just approved at I-130, what is the next steps and how long is the process? My wife is bright. I'm not sure I understand that. I'm in the United States, falling for her here in the States. I don't really understand your question. But Seymour, if you're here in the United States, my question to you is, why didn't you file an I-485 adjustment of status at the same time? You could have done that in one step. So if you didn't do that in one step and your I-130 has been approved, the next step definitely is to file the I-485 adjustment of status, file the I-765 so you can get a work permit, file the I-131 so you can get advanced parole. All right. Rob Jim says, if one got a green card in 2022 December, when can he apply for citizenship based? His green card is marriage based. So your green card is marriage based and you got your green card in December 2022. So first of all, if you're still with your spouse, then you can apply for a naturalization within 3 years, right, of getting your green card. 90 days before the third anniversary, you can apply for naturalization. If you're no longer with your spouse, you have to wait for 5 years. Now, if it's a conditional green card, remember that the conditions need to be removed before your citizenship application will be granted. Now, a lot of people, what they do is, if you're still with your spouse, something you can do is within the third year, 90 days before the third anniversary of your green card, you can go ahead and apply for the naturalization. And typically you will get an interview date, which hopefully will hasten the adjudication of your I-751. All right. All right. Let's see. I'm seeing some questions I don't understand. Can I travel to the Caribbean if I'm waiting I-485 by Godda? I don't know what that is. So, Lighty says, I respond back to USCIS notice of intent to deny before the deadline for SIJ. My family court hearing by the family court was approved. When will they respond to me? Back to me? I don't know enough about your case to be able to answer that question, Lighty. Okay. So let's see. I'm still on Instagram. Let's see. Somebody else asked, I filed for my marriage petition. I'm married to a U.S. citizen. I got a work permit and parole. I have 2 questions. Why is the notice of receipt taking long? It's been 1 month. That's not long at all. But if you said you filed the marriage petition, you did the work permit, that's not really long at all. So just hang in there, okay? So Lighty Bola says, can an SIJ green card holder travel back to his homeland country? If you have SIJ, that's a deferred action. That's not a green card. If you have only SIJ, you cannot travel out of the United States because it's a deferred action. If you finally get your green card, even if you get it through SIJ, you're a green card holder. You can travel. All right. SIJ is a deferred action. It doesn't, you don't travel with it. Okay. All right. So somebody says, my friend came through the border 5 years ago, but married to a U.S. citizen. Will he still be eligible for the PIP in 5 years to come because he's about filing for I-601A? So according to the law we have right now, we don't know if there's going to be another PIP, and any changes in that law. The law we have right now says that you must have lived in the United States for 10 years as of June 17, 2024. So he's not going to be able to apply for PIP. I would recommend he file his 601A. All right. All right. So Simply Dear says, should I upload pictures to my I-130 as evidence of relationship for spousal visa? Of course, you should have pictures showing that, you guys are, showing a slice of your life. Pictures typically tend to do that. And you're also asking, would it be better to stay in the United States during the immigration process versus living abroad? Well, that's a question that if you're in the United States already, it's going to be quicker, right? If you're in the United States already. And if you're in the United States and you're out of status, if you leave, you might have some kind of bar to come in back, right? So whether it's quicker, of course, if you're here, but a lot of people prefer to stay abroad and get their papers filed because a lot of times you have to wait to get work permit. You have to wait to get travel permit. And some people don't want to just sit here doing nothing. So it's a personal decision. But if you're already here and you're out of status, if you leave, you're going to have some kind of bar, if depending on how long you've overstayed. Okay. So Mac Dara says, can my U.S. citizen wife file for my kids in Nigeria? When filing her citizenship, when filing the form, can she put them as her stepchildren? So Mac Dara, that's a really great question, and I want you guys to listen to this. Immigration has specific definition as to who qualifies as a stepchild. So for your U.S. citizen wife to be able to file for your children abroad, and for them, they have to be her stepchildren. And for them to qualify as her stepchildren, you have to show that as of the time you married your stepwife, your children were under 18. And if they are, definitely she can file an immediate relative petition for them, for each child separately. All right. So somebody says, looking from YouTube, somebody says, my I-765 employment authorization application based on marriage has been pending with NBC for over 7 months with no update. Is it normal? It's not abnormal. Sometimes it takes up to 10 months, sometimes even more. You can try to expedite it if you have a reason to expedite. Are you almost homeless? Are you being kicked out of your house? You could try that. All right. So somebody says, can a conditional green card holder travel the same way as a non-conditional green card holder? Yes, you can. You have a green card. You can travel. All right. Just remember to remove the conditions when the time is, when you have to remove it. Okay. Somebody says, how can I get a quicker interview date while waiting for an interview date from the embassy on my I-130 visa after my documents have been confirmed? If anybody knew how to do that, trust, they will all be doing that. Unfortunately, the line is really long. Okay, in some countries. All right. Let's see. I should take. Let me take a couple of questions from TikTok. So let's see. I'm trying to see if I can get a question from TikTok. Good morning. Good morning. So somebody says, I put in for my citizenship but was denied. Can I file again? Well, yes, you can, depending on the reason you were denied. So this would be a good time to talk to an attorney, because sometimes you're denied for something that you can change. You could be denied because you didn't pass the test, which you can definitely reapply. You can deny because you may have been denied because you have some issue. Maybe you have a criminal past and you're within the time period within which a naturalization application would not be granted. Or maybe you might even be able to do something, that requires you to take some affirmative actions to correct whatever it was. So it depends on why you were denied. So if you want us to assist you, feel free to call us 973-993-1900. We can do a consultation, review your records, and figure out why you were denied. And we will be able to tell you whether you should reapply again. There's some people that may never be able to become U.S. citizens. Never. Because of some inadmissibility or some reason. So, we need to know what the issue is. So let's see. Hi, Dahlia. How are you? Good to see you. All right. I tried calling you people, no answer. Did you call 973-993-1900? Call us again, okay? Confidence. All right. So Lady Monifa says, can an inadmissible 601 file with an I-130 due to denied petition before? I don't understand this question, Lady Monifa. It sounds like your 601 was denied. We've had cases where 601s were denied before by prior attorneys. The person came to us, we refiled it, and it got approved. So we may be able to help you, but we need to know why you were denied and what's going on with your case. I cannot tell that from a sentence on live, okay? So Uchmani5 says he's an Australian citizen with 7 years experience as a clinical nurse in Australia. Was the best permanent visa option. So Uchmani, as a nurse, you can come in through employment. You know, there are America needs nurses, so there are lots of nurses who are being people are filing EB3 for them, and you should look into that. That's definitely a good viable way for you to come into the United States. Okay. So Suleiman is asking, can you tell me about US visa interview? What documents required to take there? What visa are you going for? It depends. Are you going for B1, B2? With the B1, B2, you need to show proof that you have ties to your country, you know, because they need to know that you're not going to come to the United States and not go back. Such proofs consist of you have a job, you have property, you have family, and they also want to have bank statements or whatever it is to show that you can afford to take care of yourself while you travel to the United States. But regardless of what you bring, they can still deny you if they feel that you're not going to come back. All right. So, all right, guys. So Christy says, if someone is in the United States and had an I-130 filed for him by their sibling, but has overstayed their visa, what can he do while waiting? Christy, that's a really great question. Unfortunately, when a sibling files for you and you're in the United States and you have overstayed, it gives you nothing, absolutely nothing. You just have an approved I-130 when you get it, but you're not going to be able to adjust your status and stay in the United States unless you can file a waiver for your unlawful presence. And that waiver would mean that you must have a US citizen or green card holder parent or spouse who would suffer extreme hardship if you were not allowed to stay. And if you file the waiver then, because it's not now, it's then when your priority date is reached, if you file the waiver and you're approved, you have to go back to your country and consular process. But for while you're waiting all this time, you don't get a work permit, you don't get travel permits, it gives you absolutely nothing. All right? All right. So Deboye says, I'm a citizen since 2020 and my children have 10 years permanent card. Can I apply for the US passport? Although they live with their mom who's not a citizen. Deboye, yes, there's some requirements for children who can get derivative citizenship from you. So we would need to get more information from you on that, and then we can advise you. So give us a call, 973-993-1900, and we can assist you with that. All right. All right. So guys, I'm going to take one more question, and then I will have to log off for now. So LLK says, is T visa faster to the green card than VAWA? Yes, 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 guys. T visa is faster, and I love the T visa because it's really great with inadmissibilities. It really is great with inadmissibilities. So if you qualify for a T visa and you qualify for VAWA, depending on the context, depending on what's going on in your case, it might be better to go with a T visa. So talk to your attorney and see if that's something that you can do, okay? All right, guys, it was a pleasure chatting with you guys today. And so I'm going to get back to work. It's Friday. I wish you guys a wonderful weekend. And TikTok, it was a pleasure being here. And I will include you guys in my next live. So be sure to follow me, okay? Take care. Bye-bye.